An issue that goes around the listserv on a pretty regular basis. Question in light of all the states that have decriminalized, medically legalized, and fully legalized. Is the odor of marijuana probable cause? Is it enough? Excited to hear a case law summary and experience? Mark.
Thank you. I am going to talk about the odor of marijuana, and I'm specifically going to be talking about how it concerns people who practice in Colorado and Washington and the 19 other states, including the District of Columbia, that have medical marijuana. Because to some extent, whether or not it is legal, it can affect how a probable cause determination gets made. And I'm just wondering, out of all the people here, if I could just ask anyone, has anyone dealt with this specific issue before, where mostly people who live in states where marijuana is legal to a certain extent, where they've had search warrants and they've been able to raise this issue about either medical or legal marijuana growth, where police have used smell to base the search warrant.
Yeah, I have a case right now where that would smell from a commercial building and smell of marijuana gets a search warrant. It's a legal collective for medical purposes. They shouldn't have the search warrant in the first place.
And what state is that?
California.
It's California. Okay. And what stage is it at? And so you're challenging the search right now?
It's been a year and we have not even set a prelim yet.
Okay.
So I haven't filed a motion to suppress. I filed a motion to dismiss because of immunity. And that hasn't been heard yet either.
Okay, I think somebody else. Sean, you had one, right?
I've had a couple where it's the blacked out windows plus the smell of marijuana. So a couple other little things. I've always argued in medical state it's not probable cause. In the past, the judges have said, well, for everybody else it's illegal, so it's still possible. So you're right now in life that it is legal for everybody else. What is the situation? But in the prior ones, both searches were upheld.
Okay, and what counties were those in, if I can ask?
Fort Collins and Colorado Springs. And
were those, well, Sean and I have actually had this talk about judges that are less friendly than they should be towards people who have medical marijuana now, right, with Amendment 64. And were those with less than friendly judges towards the medical marijuana issue? Okay, and Lee, I think you had your hand up.
It's an active issue in warrantless cases in Oregon.
Yep.
And there's a petition for review pending in the Supreme Court to hopefully pull back from a case that says basically that smells is probable cause because it's contraband, not because it's evidence of a crime.
And by the way, I came up with the name of this lecture just for you, Searching for the Smell. I figured you'd get that one.
I did, I appreciate it.
Thank you. You're welcome. Okay.
Anytime you can work those lyrics in.
I try.
I appreciate it.
For all you non-deadheads out there, Phil Lesh wrote a book based upon one of his lyrics, and he called it Searching for the Sound. And so I just kind of did a little riff off of that. But I think that's the first thing that you have to analyze when you decide, when you see a search warrant, and you have to analyze, okay, am I in a state that where the possession or the cultivation or the possession, the cultivation, or use of marijuana is legal. And I think that's the first thing that you have to do. And the first thing that you have to do is you really have to familiarize yourself with the law. And for us in Colorado, we're opening a new chapter here. So I'm going to kind of address it towards people in Colorado because I'm more familiar with the Colorado laws because I practice in Boulder than the other laws in the other states. But we're opening a whole new, let's call it a chapter because of Amendment 64. And I know that there's people in this room like Sean who's more familiar with all the details of Amendment 64 and especially the new law. I pulled the bill up, and you can actually go, if you do practice in Colorado, you can go to the Colorado legislative website. That's what I did, and I pulled up the new bills. And I read them, and to be honest with you, there's very little, and Sean, correct me if I'm wrong, but there's very little about people that are just growing on their own. It's mostly about retail situations, and it's the DUID or driving under the influence of drugs law that they really address. They don't really talk about individuals who are possessing or growing marijuana or using marijuana or cannabis. And there you have to actually go to the Amendment 64, because Amendment 64 actually sets out the limits of how many plants you can be growing. And it talks about private, you have to grow them in private. Nobody's really defined what private is yet. That's probably something that's going to be litigated. I know in Boulder there was a movement to make private mean anything that's not indoors. And I don't think that that got very far, because Amendment 64, as you can imagine, passed overwhelmingly in Boulder County. And the people in the city council are kind of running scared of becoming too overbearing on that, and only time will tell if and how they try to localize the ordinances restricting that. But I know I'm planning to start my garden pretty soon, so in my backyard. So I'm not too worried about.
Maybe if I could jump in on that, Marc, it was really interesting. I was on the law enforcement committee, which I was kind of calling the hand job committee because it was law enforcement. Yeah. Anyway, one of the tasks that we were given was defining public and enclosed lock space and the terms in the amendment. And you couldn't get law enforcement, you couldn't get them to get real. You know, go to the general task force, and all the general task force would agree, if you're smoking on your front porch, you're not doing it, you haven't met the openly and publicly prong because it's not public space, it's your own front porch. But it raises super interesting issues that you just could not get law enforcement to lose the mindset of, oh no, if I can see it, then it must be public. And so it's going to be a super interesting litigation for you.
I think it will be. And I can kind of give you a little war story about a case I had about a year ago in Jefferson County, which is not a medical marijuana-friendly county at all. But I had a long-time client, kind of a repeat customer, who is now a grower, or he's actually on a little hiatus, and I'll tell you why. But anyway, he decided to put up one of those plastic greenhouses. You guys ever seen those things? They're opaque plastic, white opaque plastic in his backyard. And and under the medical marijuana amendment, he had the legal number of plants. He was a caregiver. And he had the legal number of plants, and he had them all tagged because he followed all my instructions to the letter, and had all his plants tagged with all his patients, and they the cops, first of all, they said they could see it from his front yard, which was totally a lie, because he had a 7-foot-high fence around his backyard. You couldn't, unless they got up on a step ladder and looked over the fence, there's no way they could see into his backyard. But what they did is they went around to the neighbor's yard in back of his house and peered over. They went up onto the second story of the neighbor's house. The neighbor let them in, and they peered down, and they saw this opaque, structure, right? And there was a flap that was open, and with binoculars they could see there was a green leafy substance growing in that opaque structure.
There's a plant in a greenhouse?
So, based upon that, they bullied their way into the home, and that's another issue, whether it was a consensual search or not. But they didn't get a search warrant in that case. But they charged him because they said he wasn't following the caretaker regulations because he was growing in a public space, in a public place. And my client did not want to, they dangled what they call a diversion, which is basically a deferred sentence in front of him, where they said if you keep your nose out of trouble and you're a good boy for 18 months, then we will dismiss the case in its entirety. So he took that rather than go through a suppression hearing, but actually Sean and I talked about that case, and the judge I was in front of, I think you had done a trial before in front, and he was extremely unfriendly to the medical marijuana defense.
Who?
McNulty.
Oh, yeah.
Yeah.
So,
So-
the case on appeal, I couldn't mention the phrase medical marijuana.
Right.
For a dispensary undercharge.
So he, after I told my client that, he did not think that a suppression motion would go well in his favor, and he took the diversion. Kelly?
I had a client in the early days of the Oregon Medical Marijuana Act who was collecting signatures for a dispensary initiative at the state fair, and he went in to use the porta potty and medicated, and when he came out, they cited him, and the judge said that he didn't transform the porta potty into a private place simply by closing the door. Because I swear to God.
That's
Well,
bad.
if you
Judges
do-
that are not friendly will say, incredible shit, and there wasn't any funding, and I didn't have the energy.
Now, if you knew about one of Jason's former clients, who was the porta potty peeper in Boulder, the guy who was a yoga guy who actually climbed down into a porta potty to look up through the bottom, that may have been.
That was
Yeah.
so gross. So, I remember that. Yeah, I did too.
How we digress whenever I lecture. I don't know how this always
Run it
happens
back,
to
run it
me.
back.
But I-
Okay, Jefferson County, your guy is charged.
It all suddenly.
But I'm in front of Mr. Goldstein here, so I gotta be good because he's gonna kick your ass. So, anyway, I think that's the first thing you gotta do. So the first step is you have to analyze, okay, where am I at? What are my state's laws? I think a very interesting state, is anyone here from Alaska? Nobody's here from Alaska. Alaska's got some very interesting laws concerning marijuana that are really interesting to read. Yes, go ahead.
Mark, can I just ask you back on that suppression issue?
Yes.
When you were preparing for that, you've given us a factual scenario. What issues would you have brought up in the suppression that you believe or were comfortable that you would have prevailed on?
Well, first of all, it's not a plain. The cops were saying it was within plain view, and I don't think it's not in plain view at all. There's no way. I mean, we had an investigator out there. We took pictures. We did it with a tape measure. There's no way that you could see into that backyard. And we also the greenhouse was still up, and so we were able to take pictures. We couldn't do it from the neighbor's house. Obviously, this neighbor was not a friend of my client's. But we think that we would have been able to prevail, that it wasn't in plain view, and therefore there wasn't probable cause to. There was nothing to indicate that there was actually,
Did the cop in the warrant or the affidavit state that the green leafy substance was marijuana?
Well, it wasn't. Let me clarify. This was not a search warrant case. This was a case where he went and they brought in the whole gang came, and they knocked on the door and they said, if you don't let us in, we're going to get a warrant, and really kind of browbeat my client's girlfriend into letting him into the house. So consent was an issue too. But if there wasn't consent, then we go back to it's a warrantless search. So was there probable cause, and should they gotten a warrant? So we can go. You have to go down that whole road. So there were a lot of interesting issues regarding that, and but I'm analogizing it more to the warrant issue. If they had gotten a warrant, how would you deal with that? The other thing is I practice law in federal court too, and I don't know how many of you practice in federal court, but the thing that I'm constantly reminded of, and I know that everybody in Colorado is well aware of this, it doesn't matter what Colorado law is. The feds don't have to follow that at all. And so what we see in Colorado is that there are these drug task force where there's usually some federal involvement. And it's usually in the form of either the DEA or ATF. And I don't know if a lot of you guys do federal law too, but if you're in federal court, then all bets are off because you have no protections under state law. And the federal judges in Colorado have been extremely hostile to raising the medical marijuana defense. And I'm assuming they're going to be extremely hostile to also raising the Amendment 64 defense. Yes?
Could you talk about the task forces for a minute in Colorado? Because, I've just noticed it a couple times in the news in the last year that since Amendment 64 passed, that a task force will say, we no longer have the money to continue operating and we're disbanding. And if I remember right, there's been at least 2 task forces in Colorado that have said that in the last 6 months. And I'm just wondering, I guess I see that as being a good thing. But-
Well, I wouldn't bet the farm on that one.
Well, that is my favorite line of cross-examination for the narcotics detectives, especially North Metro, who are the biggest liars.
No, I think West Metro is right up there with them.
They are up there with them, yeah. But it's, but okay, so maybe North is dumber because they'll contradict things that they've sworn to in writing. But anyway, they police for profit. And so as a result of the constitutional amendments not allowing the forfeitures to go forward or them being on the hook when they mess up, so that's one time of messing up and losing all the money that they've gained from some of the forfeitures, they are running out of budgets, which will keep trying to put them out of business.
Well, and let me tell you a little weapon that I have used with success against the task force that you might want to try. And what I've done in federal court is I had a case where the issue was my client was arrested. This was a meth case, and he was arrested after a search of a house, and he was brought in, and it was a task force. It was a combination of federal and state law enforcement, and they were actually questioning him, and they told him if he snitched, this would not go fed. And so what did he do? He snitched, but he was in custody, so he had his little brother drive the task force guys around to where all the dealers lived, and basically and snitched on them. Well, guess what happened? He got indicted in federal court. So what I did is I filed a motion for discovery of all the, this was South Metro Task Force, for all the South Metro Task Force records concerning this guy. And after stonewalling for about 6 months, the U.S. Attorney finally dropped the case because he was so disgusted that the South Metro Task Force guys were not following the judge's order to provide the records. They refused to turn over anything. I don't know if people have had the same issues. I don't know if you've had the same issues with the task force people, but
Well,
they're terrible.
they're terrible. I mean, they're the biggest liars. They're so easy to catch in lies. It's great because I don't know if it's sloppiness, just flat out dishonesty, stupidity. It's so hard to put your finger on because there's so many lies. But I just had a trial with some of them where they swore to 6 different things, and they might have gotten away with it had there not been 3 search warrant applications previously and amendments made to them, and just shit made up basically. And so it's real easy to get them to be exposed for the liars that they are, but it doesn't help your client whose life is on hold and has a lot of problems because he's being charged.
Right, but you can
use
use that as a weapon, though. I mean,
Yeah.
use a subpoena ducus tecum or a motion for discovery, and get them to bring in their records. I'm sorry, this isn't my phone, so I don't know how to work it. But
I don't know whose phone it is, maybe the last speaker, Michelle. Anyway, it is great to vary them. When I was a prosecutor, I actually ended up dismissing a couple cases because there was the task force, which is DEA involvement, and if you really go after them in discovery, at least in Colorado, you are entitled to what's in those files, and once a lot of it is actually, the DEA is not going to let them turn over, and you hit a wall, and if they can't produce the discovery, you are entitled, either the DA should dismiss it, or you have major issues that are going to make them run. But in terms of the task force that still exists, if we keep on them, they are slowly going to fold, because Sean will tell you story upon story. Go, Marc,
isn't the key question on smell be probable cause? Probable cause means an articulable suspicion based, on actual facts, not a hunch. Is the smell alone probable cause in a state where it's legal for everybody? They would have to be able to say they could tell from the smell how much you were growing. And I think most cops could never say that they know this smell means 10 plants, because there is a limit on the number of plants. But by itself, it shouldn't be probable cause.
that is a perfect segue into my hypothetical, which is on page 2. And actually, if I can have that phone back, Tommy, Can you? Sorry. We have a guest that's appearing by long distance, the miracle of modern technology. His name is James Woodford, and James is now, did anyone bother to read my hypothetical before? No, that's okay. And this is actually an actual case that actually happened. An actual case that actually happened. Doesn't that sound good? Sounds like lawyer talk to me, right? Okay. So I think this is good.
Hey, Dave, you in there?
Who is it?
It's Dave.
Hello?
Dave.
Yeah.
Hey, it's Mark.
Hi, Mark.
How you doing?
Good. Are you in front of the audience?
Yes, I am. They're all sitting here with rapt attention, waiting to hear your words of wisdom. Anyway, I'm gonna. Do you guys? I'll describe the hypothetical. It's in my materials if you want to look at it. And this was actually a real case that I had. And to set this up, you have to understand. Downtown Boulder is full of these old Victorian houses with the big front porches. You guys know what I'm talking about, right? And where you walk up to the front door, and it's been subdivided into apartments. And my client happened to have an apartment where he had a window. His bedroom window was right. It was the front porch. So it opened up, and it was the front porch, and was right next to where the mailboxes were. So imagine this if you can. There were a series of mailboxes, and this is not growing marijuana. This is stuff in the bags already dried, but same kind of issue because I think their analogy can be made. And the cops got a tip that he was dealing weed and that he was getting weed from, and he had the really good weed. So they walk up. It's a beautiful spring day like today. And they walk up, and his window is open. And they said from walking up to the window that they could smell the odor of fresh marijuana. Not growing marijuana, but fresh marijuana. So based upon that, and he wasn't home, by the way. They came to do a knock and talk. And does everyone here know what a knock and talk is, or do I need to explain that to anyone?
Why don't you explain it anyway?
Okay. A knock and talk is what the cops try to do to get around warrants. What they'll do is they'll walk up, knock on your door, and go, hey, just wanted to know, do you have anything legal in your house? And can I come in and can I come in and take a look? And of course, everybody says, yes, come on in, officer. I mean, that's what the police reports say anyway. I don't know. My clients say they stick their foot in the door and just walk right in. But the cops all say that they're invited in, and so that's what they try to do to get around a search warrant. And then it's consent, and they don't have to worry about that. But in this case, my client wasn't home, so in the search warrant, they had confidential informant, blah, 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 with no identification, which they don't have to have, but no indicia of reliability or anything in the search warrant. It was just, somebody says this guy is dealing weed, and we walked up to the porch, and they didn't even know how they couldn't even tell in the search warrant, or they didn't indicate, or with any kind of what I felt was reasonable certainty, that window was actually the window to his apartment. They just said they walked up, his name was on the mailbox, they walked up, the window was open, they could smell weed, and so they, based upon that, they got a search warrant. Now, they went in and they searched his house. Now, unfortunately, my client did have a large amount of marijuana in his house. But now this is after the medical marijuana amendment. But he also had a shotgun in his house, which is not a good combo, because all of a sudden you're looking at a possession, and with probably worst case scenario in Boulder is a probation sentence to a mandatory prison sentence with the gun. So the stakes were extremely high for him, and of course he had no criminal history. He was not on the task force radar as somebody who was a known dealer or anything like that. He basically took the same kind of deal, but where he got a deferred sentence, and he successfully completed it, by the way, because he did not want to run the risk of getting, it was an all or nothing situation for him, because the DA has made it quite well known to me that that the deferred sentence was off the table if he went through the motion hearing and went through a suppression hearing, because then if he did, he either went to trial or pled guilty to having the weapon enhancer with the pot, which would have sent him to prison if we would have lost the suppression hearing. He did not want to roll the dice on it. But anyway, that was the basic premise here of the hypothetical. And Jim, are you there?
Yes.
Okay. So the reason I called Jim and asked him to talk today, because he's going to just give us, if I had called Jim as a witness regarding, the best part about this is that the postman or the mailman, where he delivers the mail, is right next to where this guy's window was. And he was there just before the cop showed up to do their little smell test outside of the window. And we actually tracked him down and interviewed him. And he said, you couldn't smell a thing. And we said, well, do you know what marijuana smells like? And he's a Boulder postman. Come on. Of course he knows what marijuana smells like. So he said, and it was really pretty funny when we talked to him. But he said, no, you could not smell marijuana coming out of this guy's apartment. And he had been there like 5 minutes before the cop showed up. So, Jim, if I had called you as a suppression hearing, how would you be able to help out my client?
Well, the first thing I would tell you about is my experience with knock and talk cases. I've testified in many of them, and over the years, and have actually gone to the houses and done an airflow test. And the thing I've learned about houses is that they are constructed so that when you open a window, the air comes in the window. Or if you open the door, the air tends to come into the door. You know the old saying, get up and close the door, you're going to let the cold air in? Well, air in houses tends to come in and go up and exit through the bathroom vents and such. So it's not impossible for air to come out a window, but the typical airflow is into the house. So when these officers would walk up, they would be upwind. I mean, so it makes it something to think about. And most people who live in Colorado know about the airflows of their house, and so it's a common sense sort of particular. And then the other thing is, this was packaged marijuana, 3 ounces. I understand it was in packaging. And Marc gave in his written materials down at the bottom this Alaska study. You'll see it down there, the helpful section. And now that Alaska study is it's done by the University of Alaska, and it's what's called a meta-analysis. The students or professors, whoever did the study, compiled information from hundreds of actual police report narratives, and they were doing the study to try to find out the various distances you could smell marijuana if you had certain numbers of plants, trying to do that correlation. But in that study, it's very interesting. In all the hundreds of cases they analyzed, it's very interesting. They never smelled marijuana from an exterior of a building if the marijuana was packaged. And so here you have a peer-reviewed study that would go a long way to be convincing that these officers on this porch could not have smelled marijuana from packaging. I know that you would have to agree that Alaska is not Colorado and those kind of things, but still it's something you can point out, a peer-reviewed study. You have the training issue. Down in Marc's written materials at the bottom of helpful cases, there's one case in there that I was glad to see, and that's United States versus De Leon. And De Leon's a 1992 case handled by Pat Stiley over in Spokane, Washington. And everybody there at that meeting probably has heard of Pat Stiley. He got me to testify in that case about the training needed. If you read that case, the footnote that I'm mentioned in, I'm the very last word in the decision. The testimony of Dr. James Woodford. The federal judge was very interested in the amount of training that an officer should have. And this you know, the odor of marijuana, most people sort of think they know what it is, but really when you really get down to it, there are lots of things that smell like marijuana, what's called raw marijuana or unburned marijuana or growing marijuana. One of those things, for example, is Heineken beer. Have you ever noticed? Did you notice that Heineken beer had an advertising campaign that referred to the skunk aroma of Heineken beer? If you do blind tests with Heineken beer, you can, with people who know the smell of marijuana, it's amazing how many people will think the smell of a Heineken beer bottle, after you've already consumed the alcohol. Try it yourself. You'll be amazed at how close it smells like skunk marijuana. So you have to have training, and the courts are much more interesting in this idea of training because of these dogs. The courts in the Harris case and Jardine's case out of Florida, you know, the new Supreme Court cases, they're talking about, you really have to go in and look at you do have this opportunity to go in and look at the training, and that's an important thing to do, the training records and things. Well, the officers have no training. They don't have any training programs for marijuana.
So they have less training than the dogs?
Oh.
Okay.
I mean, they have nothing of it. So dog training records are several hundred pages long. I just got back from a case out in Seattle just yesterday, and the training records are about over 300 pages long for this dog, and there are none for police officers. And there's one appellate decision, I can't remember the case out of Texas, where in the dicta of the appellate decision, they talk about this little experiment that I did, where I put marijuana odor in my hair and in a napkin in my coat pocket and rode up and down the elevators in the federal courthouse with the DEA agents, and nobody smelled it. The court thought that was hilarious. And so the smelling of something is contextual. It's in the context of what's going on. These officers in this hypothetical, in Marc's case, had this preconceived idea from the CI or wherever that there was marijuana in the house, and so it emboldened them to go over there and say that they smelled it, even though they didn't smell it, of course. And so you get into all sorts of these kind of things with an expert trying to explain to the court. And if you, one of the things I've noticed in doing smell cases, whether it's dog smell cases or human smell cases, marijuana cases, it's called the long sword. I call it the long sword and the short sword. The long sword is your smell argument. It's so complex. You have an expert. You have packaging. You have all sorts of physical evidence to think about. Distances the odors travel. What's the odor made of? Is it burned? Is it raw? All these. It's so complex. The judges are very interested in it, and it takes a lot of time to present it. and using my work and Dr. Dottie's publication, for example, you can actually make compelling arguments. But the thing is, judges don't want to rule on the compelling arguments. They'd rather have the cops go on out there and do say whatever they want, and just go ahead and keep making these cases because it's good for business. But the point is, if you present the long sword, the judges will do everything they can think of to rule for you on what I call the short sword. And the short sword is some sort of legal particular thing that they would never consider and never rule on had you not presented the long sword, had you not given all this compelling presentation about odor. Out in Seattle the other day, this past week, we had 3 days of testimony about odor. And at the last day, the judge was thinking, oh, I think there's some minor thing wrong with the search warrant. And I'm pretty sure he's going to say, oh, this tiny little thing of the search warrant that's what I'm basing my opinion on. And he's not going to make any comment at all that the officers lied about the smell. He's not going to stop them. He's not going to do anything or even send them any messages. It's like it never happened. He's just going to rule for the defense based on the short sword, legal, particular little thing that, and if he would not even be thinking about if you didn't have an expert where you did not present the long sword. He could always say, oh yeah, the search warrant wasn't filed right or was sent by email or whatever, and it should have been signed. He will say, if you didn't have the smell expert, he would say, it doesn't matter about the little mistakes in the search warrant, because the odor's there. I'm going to rule it like that. So it's a long sword, short sword approach, and that's basically my presentation.
Jim, I wanted to talk to you. Jim and I talked about we divided the odors into 3 different categories. One was fresh marijuana, which we've just gone over. That basically it's virtually impossible for the cops to smell fresh marijuana. But I know that Sean had a question about growing marijuana or a marijuana grow. And when I talked to Jim, he said burnt marijuana, you're kind of SOL. Because that one, that's pretty much a given. But I'm going to touch on that in a minute after we get off the phone with Jim. But talk about, for a minute, the odor of growing marijuana, please.
Okay, the odor of growing marijuana is, you want to know about what it smells like or the distances? Or
about whether or not there's anything unique about it, or could it be mistaken for other things?
Oh, yeah, there are many things. There is a new book, well, I call it new book. I guess maybe it's 2 or 3 years old now. It's called What the Nose Knows. And it's by Avery Gilbert, who is a well-known smell chemist. And he has a chapter, interview me about marijuana, smelling marijuana in there. It's interesting to read. Where I talk about the different different smells that growing marijuana has, ranging from things like skunk we talked about, and things like sweet sativa that Carol Wack talked about. In Florida and the East Coast, you have marijuana smells much different than West Coast marijuana. In Florida, for example, it smells, they have bubblegum marijuana, the hydro marijuana, the sweet sativa.
So Jim, I just have a couple more minutes left. So
okay.
The basic thing is, if we have a growing marijuana, if we have a search based on a grow or the smell of fresh, you're a good resource to talk to see how we can show that this is kind of junk what the cops are seeing in their search warrant.
Exactly.
All right. Thank you so much. I really appreciate your availability.
I appreciate you calling me, and my regards to all my friends there in the audience. All right, bye.
All right. Thank you. And thanks to Tommy to letting me use his iPhone, because my phone, the technology just did not want to work. So the point that I'm trying to make is, all right, so let's say, for example, we bring in somebody like Jim, and he says, no, this is all junk science. There's no way these cops could have smelled it. Then you're left with the basic Franks issue. And so everybody here, you guys all know what I'm talking about with the Franks issue, right? Where the cops lied. So basically then what the judge has to do is he has to use his metaphorical scissors and cut out the stuff, and then he has to look within the four corners of the search warrant to see if it still rises to probable cause. Now, what Sean raised was a really good point, because now in Colorado, at least with Amendment 64, I don't think it's really clear, and maybe somebody, you know, Sean or somebody else that's more familiar with Amendment 64 can tell me. But what I was thinking is, okay, let's say you live in a house with 5 adults, right? Okay, or let's say you don't live in a house with 5 adults, but you've got 5 friends, they're all adults, they all want to grow pot. What's to stop them from coming over to your house? Because in Colorado, you can have 6 plants legally under Amendment 64, right? 3 immature and 3 mature. So what's to stop you from them growing 30 plants in your house? I don't think anything. And I think that you can use that. So the point that I'm trying to say is know the laws first, and then look at the search. Is it a search without a warrant, or does it have a warrant? If it does have a warrant, what kind of smell is it based on? Those are the kinds of things you have to analyze it, and I think if you do, I think that you can come up with a winner a lot of times. If anybody ever wants to call me, I'd be glad to talk to them and share what I have. I think my information, or email me, I'd be glad to. I know that Sean's also really open. We talk quite a bit about this kind of stuff. And I know James Woodford is a really good resource too, and he's a good guy to draw on. Any questions? Yes.
And a couple points. As a mimicking fresh pot smells, also acetone and epoxy used in many manufacturing processes for composites. When they're mixed together, they get a very skunky smell. So that look for anything manufacturing around your defendant's, your client's house, because it can pollute a whole. If you got somebody manufacturing some composite material and they're using acetone and epoxy in the process and they got it vented out, it can fill city blocks, and it kind of smells like certain strains of weed. Another thing, when I did some consulting in Northern California, they were doing a lot of flyovers and seeing, well, you can see them on Google's map. You can see people's gardens everywhere in Tehama and Butte and Shasta and Trinity and Mendocino and Humboldt. And we had cases where we tried to argue, similar to the smell issue, looking at the 4 corners of the warrant. Okay, we flew over, we seen 15 plants in their yard, but they didn't go do a compliance check. They didn't do to see anything if they were violating the medical marijuana law, because the argument is just seeing marijuana in somebody's yard in Northern California doesn't mean you're articulating any probable cause that there's a crime being committed there, unless you go and verify and can put in your probable cause in your search warrant that, yes, I went and checked, they didn't have a medical card, they had 15 plants in their backyard, there's my probable cause. No medical card, plain view 15 plants, now I got probable cause. But if it's just plain view 15 plants and then not going further to verify that those are in violation of California law, it doesn't seem like the search warrant would be applicable. So I think you can use plain sight cases just like the smell cases and make similar arguments on plain sight cases. Just like your guy looking over the fence.
Right. And I'm going to make one more point, and this is specific to the Colorado practitioners here. One thing that people didn't really get, when Amendment 64 was proposed, I actually read the whole thing. And it makes growing hemp in Colorado legal too. So the issue is, I think that you can also use that in your search warrant, because you know how the cops just love to say hemp should not be legal because we can't tell the difference between hemp and weed, right?
They smoke it, they know.
Throw that back at them. You know, I don't know, but I mean, this would be a good thing to talk to James Woodford about. Does hemp smell the same as weed? I mean, yes. And hemp is totally legal to grow in Colorado now, from what I can tell. One more question, then I gotta go.
Yeah, so, you know, in the Colorado State Legislature this year, when they were debating the DUID bill, which, you know, permissible inference that got passed this year, I recall one of the legislators saying that smell alone in a car is not going to be enough to establish probable cause.
Well, usually I wasn't in trial for all that, because I had tried to get the enforcement subcommittee to propose a statutory provision say, just getting rid of the ambiguity, getting rid of the fight, to say odor alone is not enough. We already know that's what the Supreme Court says in terms of alcohol, so let's just stop needlessly arresting people in the meantime until this funnels up through the courts. And not enough people are willing to buy it, but I ultimately think, especially in Colorado, we're going to get there. There's cases out of Alaska, there's some out of Massachusetts that deal with the issue of probable cause and odor, and the judges are putting a lot of qualifications on it. And so when you have states where it's fully legal, or states at least where it's legal for medical, the biggest arguments I've seen from judges are, well, how can they tell? I mean, just because he may be medical and they can show he's medical doesn't mean he's in compliance. And it's a real bastardization of the Fourth Amendment to say, oh, the cops can come in if maybe it's not legal, but maybe it is, and search your house. They don't get to come in to make sure that the number of oxycodone in my medicine cabinet matched my doctor's script. They don't get to do that.
Or if I weigh 497 pounds and I can't get off the couch and I serve macaroni and cheese every day. Sorry.
Well, there's all
The
kinds of...
argument is they shouldn't be able to use the search warrant, get into the house, and then establish probable cause that he's violating the law.
Right. In other words, when the Fourth Amendment prohibition goes above all of this, and they need more.
Well,
And I think we're going to make a lot of headway with those
In
arguments.
some places, it's already the practice, though.
Yeah.
There was, Gary, I'm cutting in on your time. Are you okay with this? Thank you. Okay, there's one question.
I was just gonna say, in California,
Okay.
in California, the issue of probable cause, let's just put it this way, of whether or not it's medical should feed into the question of probable cause to the litigant basically reject it. And they cite the voter materials bill that went out with the voter initiative in 1996, that basically was done to reassure the public and said, that the police will not have their hands tied by this, nothing will change in terms of law enforcement, there is immunity to assert after they put their hand on your collar, drag you to the courthouse, etc.